generated during the marriage, otherwise than by external donation. And non-matrimonial property can therefore be broadly defined in the negative, namely as being assets or that part of the value of an asset which are not the financial product of or generated by the parties' endeavours during the marriage. And then examples being given of inherited or gifted to a spouse from typically a relative of theirs during the marriage, which we touched on earlier. And the example which is quite often quoted is of the springboard. The springboard itself might be a premarital asset, but then the swimmer or the acrobat who jumps off, or the gymnast who jumps off the springboard, the endeavours that they create during the partnership, assuming the partnership then starts afterwards, that would be clearly matrimonial. And we say that is generally understood to be the case. How assets are defined is then critical, we say, to the court's function, because once they become matrimonial, the circumstances in which they can be departed from are limited. Again, as per Baroness Hale, at this time, paragraph 150 of Miller, there's an underlying imperative that discrimination should be avoided. The parties have entered into this partnership, and as equal partners within that partnership, the asset should be treated and divided equally once it's become matrimonial. So the point of departure, where it's not treated as matrimonial, is also the point where one is not looking at sharing. And that is, of course, the great significance of matrimonial versus non-matrimonial. Non-matrimonial is not typically shared. Matrimonial is, and is typically shared 50-50. The paragraph in Charman, paragraph 66, which of course is well known, is again talking in terms without being able necessarily to descend to particular detail. But the principle, we would say, is something generated by or within that marriage itself. The separate property divides into two. There's, first of all, separate property is property that's not matrimonial property. And then when it comes to the individual as to who owns the separate property, we say there is no reason at all as to why that shouldn't be treated as being owned according to how it's legally and beneficially owned.
Sorry, can you say that quite quickly?
Sorry.
Separate property is
non-matrimonial property, so it's property outside the partnership.
Okay, so that's what you mean by separate property.
Yes.
Is non-marital property.
Exactly.
Thank you.
And then it then needs to be divided again as to that which is husband, that which is wife. And in most cases, that will be quite easy to determine because it will have been either pre-acquired, or it will be gifted to one of the parties, or it will be in some other way formally capable of being seen at law as being that party's separate property. And a good example of that is the 2017 money, which we say went to the wife and thereby became either her separate property, or if it went to the wife qua her role within the partnership, it became matrimonial property.
So you're saying it was non-marital in the husband's hands?
Yes.
Because it was
only to an extent.
Okay, I know you say the earnings gross 40 million, but that's gross, wasn't it? And there was tax and
yes, and then we've got
other issues.
15 years growth on that 40 million as well.
So, okay, subject to that point, non-marital property in the husband's hands given to the wife becomes non-marital property in her hands.
Yes.
So it becomes her non-marital from his.
But
okay.
If we're wrong about that...
So I can ignore the separate property as a concept. You can see it was troubling me during the course of the morning. Yes. I can just call it non-marital property.
Yes, you can.
Thank you.
Absolutely. And one of the things which I think has created a huge amount of academic discourse is Baroness Hale's use of "we live within a separate property regime," I think it's paragraph 153 of Miller. And there's a question as whether or not that's akin to a séparation de biens that one would see in France and so on. We don't need to go there. We simply say we're concerned with the differences. And then that gives rise to a difference of approach. Lord Phillips, picking up on this body of law, referred to non-matrimonial property in like terms in paragraph 26 of Radmacher, when he was talking about specifically in the concept of sharing, and he said in that paragraph 26, which is page 75 of the authorities bundle, Lord Nichols postulated that marriage was a partnership. We agree with that. When a marriage ended, each was entitled to an equal share of the assets of the partnership, unless there was good reason to the contrary, albeit that the yardstick of equality was to be applied as an ignorant rule. One good reason might be the difference between matrimonial property generated during the marriage and non-matrimonial property bought by one party's marriage or inherited by or given to one party during the marriage. So it's separate from, and that's where the use of separate has perhaps crept in. And then we have the other reference within that case where Baroness Hale picks up again, this time paragraph 140, the idea of there is a...
Sorry, is it Miller again?
Sorry, this is Radmacher of Baroness Hale, where she refers to the move to a separate property system took place in 1882. Where she says, page 111, where she refers to the 1882 Act, extended the concept of the wife's separate property, so that everything which a woman owned on marriage or acquired thereafter remained or became her separate property. There's no restriction on if it came from your husband, it's not, or anything of that sort. And she goes on to say, the system of separate property thus established remains the only matrimonial property regime applicable to the laws of England and Wales. It also meant that the wife eventually acquired full contractual capacity. And so a husband and wife could now make contracts with one another as well as with third parties. The way that property can become matrimonial, we've spent some time on this morning, and I hope I'm not going to be going over old ground, but the summary position is that it can be brought into the marital partnership either expressly or inferentially. So again, the same as a commercial partnership. And one sees an illustration of that in the Jones and Jones case, at paragraph 46 at page 207, where the example is taken by Lord Justice Wilson, as he then was.
Sorry, what paragraph now?
It's paragraph 46, I'm so sorry.
Thank you. No, my fault. Thank you.
207. Sorry, I should have gone back to 45, otherwise it won't make sense. In paragraph 45, in Rossi, Miss Mostyn, again sitting Deputy Judge of the Family Division, said, for the purpose of establishing the matrimonial property, in respect to which the yardstick of equality will forcefully apply, the value of assets brought into the marriage by gift and inheritance, other than the full matrimonial home, together with passive economic growth on those assets, should be excluded as non-matrimonial property. And then Lord Justice Wilson goes on to say, like Mr Justice Singer and S&S, I regard Mr Mostyn's proposition as helpful and subject to the fact that the yardstick equality has been subsumed within the sharing principle as accurate. Then he gives an example of non-matrimonial assets that increase in value, artworks, and so on, and passive growth. And then the last sentence, paragraph 46, analogous approach is apt in respect of assets inherited by or given to one spouse during the marriage. And we say there's no reason to restrict the gift by one person's separate property to the other person's separate property. That's gift. But if we're wrong about that, and that they're gifted to the wife qua partner, then it's matrimonial. It's money that's introduced into the matrimonial. And as we said earlier, it's definitively not the husband's separate property. The ordinary consequence of property being matrimonial, we would say, is that it's 50-50. I take Lord Phillips's point on board that this is a discretionary jurisdiction, but it's not an unbounded discretion. And in the 23 years since White, it's not really been applied outside of those that very, very limited class of cases called special contribution. And even the agreement cases, the agreement is normally to take the asset out of matrimonial property, so they probably aren't an exception either. So apart from special contribution, there really isn't any. And that's part of the respect for the equal partnership that the marriage is. And of course, one of the impacts of Radmacher, which remains controversial, is the extent to which the parties might be able to opt out of that. Well, that rather reaffirms the extent that that is certainly the starting position. And therefore, we say on a correct analysis of the court, the consequence of property being classed as matrimonial property is only in the extraordinary or extraordinary case that there would be a division which is other than 50-50. And that takes its authority from the K&L case. We've already touched on paragraph 18 in the context of the judgment, but it's page 220 in the authorities bundle is where the paragraph 18 is dealt with.
Sorry, tell me that again.
I'm so sorry. 220.
Thank you.
This is K&L. Where there's the quote from paragraph 18, which was dealt with, of which it might be said that 18b is of our application here to make that gift a matrimonial property. But he goes on to say, paragraph 21 at page 221, when we're looking at the normal effect of an asset being matrimonial, is to deal with the one exception, which is special contribution. It says, but the phrase of special contribution is now a term of art in the law of ancillary relief, which is used to describe a contribution entirely different from that of non-matrimonial property. As this court said in Charman, the notion of special contribution to the welfare of the family will not successfully be purged or of inherent gender discrimination unless accepted as such a contribution can in principle take a number of forms, including non-financial and so on. Although I think there's still not yet been a special contribution case that's non-financial. But then paragraph 21, thus the special contribution arises in circumstance which a spouse's contribution, direct or indirect, to the creation of matrimonial property has been so extraordinary as to dictate a departure within the sharing principle from the ordinary consequence of its equal division. It's therefore no accident that the court's reference paragraph 90 to the unlikelihood of departure from equality further than 2/3, 1/3 was of division of matrimonial property. That's very important in this case in responding to my learned friend's skeleton arguments, because they repeatedly say, well, what about contribution? Contribution has a role to play in two ways. Contribution defines what is separate property, and here the separate property is with the wife, or alternatively, it is found within the context of matrimonial property, but only special contribution. And as Ms. Standish perfectly properly accepted, that was not the case here. And if you have to go within that extraordinary, as it was described, character of special contribution, and we would say it follows night follows day, that just communal garden contribution, just providing an asset, is not going to succeed in justifying a departure from the ordinary rule of 50-50. And that view received further support, we say, in the Graham Work case, which again was focused on special contribution, where at page 236 of the authority bundle, paragraph 34, it was said, the sharing principle is now firmly embedded And in those cases where the resources exceed needs, the ordinary consequences of application will be the equal division of matrimonial property. To get within extraordinary under contribution, we say Mr Justice Moor had to get to special contribution, and it was agreed by everybody that wasn't the case. The Jones case also reinforces this, and that's found in paragraph 33 of the Jones decision, which is found the part that is relevant is found in paragraph 34, which is at page 205. I'm so sorry, I've taken you to the wrong references. Paragraph 33 is the preceding paragraph, where he says, my view is that in applying the sharing principle to this case, we should in the first instance adopt the approach commended to the judge by Miss Stone. We should therefore effect a division of the total assets of 25 million into the part reflective of non-matrimonial assets, so they move away, and that reflective of matrimonial assets. Having done that exercise, it then goes on to say, have in mind what Lord Nichols says, and then goes to say, the remaining step to be taken pursuant to Miss Stone's approach will be easy, partly because in this case there's no ground for sharing the non-matrimonial assets other than 100% to the contributor and 0% to the other, and partly because by contrast there is no ground for sharing the matrimonial assets other than equally. The same approach is picked up, and if I can just perhaps give the references, because it's simply an echo of what's said in those earlier cases, but equally homeopathic, is paragraph 85 in the decision of Hart, and a reference to it in paragraph 128 of Waggart, and the outcome in XH and XW is, which is found in paragraph 138 and reference paragraph 114, is again consistent with that.
Sorry,
approach.
138 and
114 is.
has it been added to our numbers, do you know?
It has been added to, and it begins. So paragraph 118 finds a home at page 442. I hope that's made its way up to.
So what page?
442.
No.
It's not been.
No.
Oh, I'm so sorry.
We've got white, but not. Somebody got spares?
I think there's some spares.
Mr Sear seems to have them at the ready.
Mr. Harvey has.
Oh, sorry, beg your pardon.
I've been called worst.
Thank you. Now, 138 and 114. You wanted
It was paragraph 114 and 138, and that's where considering the overall analysis takes place. And 114 is at page 441. Where there's the analogy is picked up of Lord Justice Wilson's of the springboard and the diver or the gymnast. Springboard predating a partnership, but the endeavours during the partnership, they are within the partnership. And there then remains the question of what happens when matrimonial property and non-matrimonial property cannot be clearly defined. And what we say about that is whether it's called an evaluation or an exercise of discretion, a court has simply to decide. And there is a spectrum within which the court might be able to decide. as to the extent to which an asset is matrimonial or non-matrimonial, everything from 0% to 100%. But it's fact dependent, so it's more akin to fact finding rather than perhaps a formal, unbridled exercise of discretion. And in Hart itself, there's a very good example where a paragraph 5 of that decision dealt with a situation whereby there simply hadn't been the evidence provided. And these are, we respect to say, primarily evidential disputes. Page 257 of the authorities bundle is where paragraph 5 of Hart appears. And what was decided by my lord in that case was after reciting Mr. Mitchell had said there was no justification for the assets divided 50-50, I think Mr. Mitchell goes on to say, the evidential deficiencies for which the husband was responsible meant that it was impossible fairly to assess the extent of any non-matrimonial property, with the result that all the parties' wealth should be treated as matrimonial property. That's a perfectly proper argument defining one of the areas in which a court might evidentially make a decision, but it is still the finding of fact. In any event, within that same case, we go to paragraph 63, which is page 265. And I think we've already touched on 62, which is where it said the classification of property as non-matrimonial and matrimonial is relevant to the application's sharing principle because the court is seeking to establish the extent to which current assets owned by the parties comprise or reflect the product of marital endeavour and the extent to which they do not. And just pausing there, marital endeavour and fruits of the partnership all come back, we said same thing, which is what's within the marital partnership. Endeavour might be just one species of it because parties might jointly acquire assets which aren't necessarily the product of their endeavour. A gift might be given to both the parties, for example. One thinks of mutual friends at weddings would create that. And it then goes on, this arises because as explained below, the sharing principle applies with force to matrimonial property, but does not applies with significantly less force to non-matrimonial. And then in 63, the third line, the weight to be given to it would depend on the circumstances, such as the nature and value of the property and the time when the circumstance of which the property was acquired. Well, that's a factual matter. And then we had the paragraph 66 bottom, which we referred to already. And then in 67, the exercise on which the court is engaged when applying the sharing principle in this context is therefore to determine whether the current assets owned by the parties or within the scope of section 25(2)(a) comprise a product of marital endeavour. The court must then decide how that determination should impact on the court's award. This raises an evidential issue, namely a factual determination, which has been described in terms of identifying whether property is matrimonial or is non-matrimonial, but which in my view is often more nuanced than this because property can be a combination of the two. And B, an evaluative or discretionary issue, namely the manner in which the factual determination is weighed when the court is undertaking section 25 exercise and deciding what award to make. And we say what that means in practical terms is that there might be one asset worth, say, 100 units, and 40 units of those might be matrimonial, 60 units might be non-matrimonial. The effect of that will be that the 40 matrimonial units will be split 20-20, and the non-matrimonial would not be invaded, save in case of need or some other exception, perhaps compensation. The emphasis in the cases we respect to say is that this is an approach which has to be adopted with a degree of broad brush to try and arithmetically precisely work out what the assets are is in the intermingling cases very difficult, and the court has to evaluate the facts accordingly. But there are cases where matters may be relatively straightforward. An example given in Hart is of K&L, and that's referred to in paragraph 80, where it said, in paragraph 80, page 269, K&L, a case in which there was no matrimonial property, the only assets being the wife's inherited shareholding in a public company. And then the question of, well, have they diminished over time? So had they inferentially become part of the matrimonial partnership? And the answer is no, they hadn't. And then in paragraph 81, there is the reference to Mr Justice Moor, who makes the observation, the treatment of premarital property is highly fact-specific and very discretionary. In addition to mingling as referred to above, Mr Justice Moor also identified what he considered to be the two schools of thought. Just pausing there. Those two schools of thought don't appear to be different schools of principle, but simply different approaches to how you look at the evidence. And the conclusion there is in respect to that authority, and of course J, L, and SL number 2, which is also cited, is found in paragraph 84, which is the court is not required to adopt a formulaic approach either when determining whether the party's wealth comprises both matrimonial and non-matrimonial property, or when the court is deciding what award to make. This is not necessary in order to achieve an acceptable degree of consistency or to achieve a fair outcome. Indeed, I consider the present case demonstrates difficulties which can arise if the court strives to adopt a formulaic approach in circumstances where there's not likely to be easily achieved because of the nature of the financial history. And then it's perhaps worth reflecting that the concept of property being either matrimonial or non-matrimonial property is a legal construct, or if it's a construct which is not always capable of clear identification. An asset can, of course, be entirely in the former, as in many cases, or entirely the latter, as in K&L. However, it's also worth repeating that an asset can be compromised both, in the sense that it can be partly the product or reflective of marital endeavour, and partly the product or reflective of a source external to marriage. I've added the word reflective because reflex was used by Lord Nichols in McFarlane's case, and reflective was used by Lord Justice Wilson in James's case. When property is a combination, it can be artificial even to seek to identify a sharp division, because the weight to be given to each type of contribution will not be susceptible to clear reflection in the asset's value. Exercise is more of an art than a science, and yet it is still an exercise, we would say, that has to be undertaken, and the natural consequence of it is that part will be defined as matrimonial and then 50-50, and part will be non-matrimonial. It will be very difficult in some cases and much easier in other cases, and there are all manner of indicia, and in K&L, Lord Justice Wilson was at pains not to close the list, all sorts of indicia that will show what that is going to be indicated by. In this particular case, we have one particularly good example, which was how it was that the matrimonial element in the 2017 money should be treated. It was simply impossible for the judge to define how much of that was matrimonial. And of course, arguments could swing either way. It said, well, the $45 million that was earned, or $40 million that's referred to by Mr Justice Moor, would then have been subject to some accruals, some perhaps passive growth that would have been in the matrimonial growth. It might have been subject to some tax, but there was no evidence about the particular tax. It might have been the money that was lost in respect to premarital and so on. The whole intermingling and mixing meant that it was simply impossible to do. So the court had to take a view, and that's where what is described as a discretionary process would take place. But it wouldn't take place in circumstances where someone has then departed with all of that, and we say made it then the separate property. The Hart case is not the same as this particular case, because there was that degree of definition achieved by the parties' agreement to transfer the assets in 2017 that enabled it to be separate property. If I may, I'm going to touch on quite briefly Ardenside land as opposed to the property, because we say that the court's approach in respect of it was not readily explicable in terms of the principle, in that
So we turn into ground 2 now.
I'm turning to round 2 now, yes, before coming back to some of the other concluding points. And in respect of ground 2, it was used as a property that the parties visited.
But can we just go in the judgment where it's dealt with? Because we've got to strip out, I think, probably the findings of fact that you can't do anything about,
Correct.
and the application of those facts to principle, which I think is the basis of your appeal.
Yes, indeed. So, yes, I was looking earlier than that. Well, let me go to where the yes. Oh yes, and then I'm going to my left hand, page 129,
Yep. Thank you.
paragraph 66. Thank you.
Right.
This is where it's where the factual matrix is established, and that is that this is about 8 lines down, paragraph 66. I've already mentioned the accommodation there was barely adequate. I'm surprised that these parties were prepared to stay there for any length of time, even if the surroundings were wonderful. Just pausing there, but they did stay there. It was a property that they stayed at. And then he goes on to say, I am satisfied that they did not go there a great deal during the marriage. There was one trip while they were in Switzerland. They visited for approximately 6 to 7 weeks per annum during the period they were back in Australia before they moved to this country. Since they've been here, there was one trip to Ardenside over Christmas and New Year, but that's basically all. And then it said, well, the wife may have been there alone once or twice, but she produced a schedule showing more trips than that, but the schedule proved to be inaccurate. And then it says about the wife being wrong about how many sheep there were there. And the judge finds in paragraph 67, it is most certainly not a significant matrimonial home. And then of the value of the land at gross figures, 31.4 million.
Sorry, can I just get the chronology right? I'm just looking at the chronology. So they, looking again at 66, Mr Todd, so they, 6 to 7 weeks per annum during the period they were back in Australia before they moved to this country. So they went back to Australia in July of 2008
Yes.
and moved to the UK the latter part of 2009.
Yes.
So the
very
judge is
short period.
talking when this 6 to 7 weeks was probably 18 months.
Yes, I think that would have been, so that would have been 2 lots of 6 to 7 weeks.
Well, one can't tell that from the.
No, all one can guess is there's 6 to 7 weeks per annum, and it looks like there was 2 years where that was possible and that could have happened. But it's
Just from the judge's fact-finding perspective, this was not year after year after year. This is where they went and spent their summers.
correct, absolutely. And then there's the description of the wife then being involved with the in paragraph 67. The farm had been owned, so this is about 5 lines up. The farm had been owned jointly with his first wife Vicky. He did not transfer it into joint names following his second marriage, to Mrs Standish, who's in court. All in all, I cannot be clearer, this farm was not matrimonialised. It was purchased before the marriage and has in essence remained the same throughout the marriage. A very small piece of land amounting to 81 hectares with a better property, there's a house on that property, was acquired during the marriage, but the parties have never even stayed in that property, and out of a total land of 6,000 hectares, the additional land was inconsequential. The wife was able to point to approximately 100 kilometres of re-fencing being undertaken during the marriage. which was $20,000 per kilometre, and that now appears to have been destroyed by the fires. And what we say is what the judge has found there, that the visits, the fact that property has been added to, might justify it being regarded as not matrimonialised to some extent, but to go to 0% is going too far. The other interesting point is the judge's emphasis on had it been put into joint names, had the name changed, then that might have been a significant part of it. Of course, during the course of the marriage, there was activity taking place in respect of this. There were the two huge fires that are referred to. There was work undertaking. The largest building on that site was, as referred to by Mr Justice Moor, acquired during the marital partnership. Most of the property was acquired quite shortly before, on the 23rd of February of 2002. And the property does seem to have gone up very considerably. It was in June of 2004, it was worth £3.5 million. And the value ascribed in the case at paragraph 17 of the judgment is £31.4 million. And this, of course, was a farm that was being worked. And so we say not only was there the visiting, but it was an endeavour that was being undertaken during the course
Except
of...
the judge found against the wife. We don't need to go into it in detail, but he found against the wife in that respect in paragraph 66.
Yes.
So I don't think that helps you, Mr. Todd.
Well, the point that's making, I don't think, is external to what the judge found, which is it did carry on as a business. It was like the gymnast or the acrobat jumping off the springboard, even if it was a springboard beforehand. It does seem to have acquired some greater value during the course of the marriage. We've already dealt with this in any event in our skeleton submissions, and I don't think they're going to be.
No, they're very clear, your submissions on that.
Just dealing with one other matter which was raised before the luncheon adjournment, it was said about the husband's needs case in respect of his property. Our case was and it was said in particular about property particulars being produced of 5 or 6 million. That was just because that's what the husband said his needs were. That wasn't our case. Our case was he could have 66, 67 million, which was easily sufficient for him to meet any needs case. The property particulars came about in the context of the husband saying he could rehouse for 5.7 million. The wife doesn't need Melsmere. I know those instructors were very keen that should be clarified from this morning.
Certainly, you must clarify anything you want.
Yes, and he'd said that in his full me. It wasn't that we were trying to push him down. Our view was that he was easily able to meet whatever he needed by those terms. There are a number of what I might call the smaller authorities, first instance authorities, which are referred to in the notes, in the judgment, which we then pick up on in the skeleton arguments, and those particular authorities, S&AG, JL, NSL, FB and PS, were all dealt with in our earlier submissions. There are many first instance decisions in any event. There was one that's a late addition to the bundle, which is not referred to anywhere else at all, and that's the J&J case. The J&J case, which I think my learned friend and indeed Mr Moore were, as he then was, Mr Moore QC as he then were in, was a case where, although the money had been transferred into the wife's name for tax reasons, it seemed to have been accepted by the wife that wasn't really hers. She accepted that the court should deal with it as a needs-based case, and the case was dealt with on a needs basis. And with what appears to be her concession, then she wasn't really seeking a share in respect of it. How that concession comes about, we don't really know, but the J&J case is plainly one about needs. And then the judicial cross-check that takes place in that case about, well, what would the sharing have been?
So on that one, my Lord Justice Moor got that one wrong, unlike Hart. J&J, he was the judge.
Well, well,
Sorry, just teasing Lord Justice Moor.
well, we say it just doesn't apply to this case because it was dealt with on a needs basis, and there seems to be very early on a concession from the wife that it shouldn't be dealt with on any other basis. And the decision of the court to say, well, we'll cross-check against sharing, then seems to have taken place within that factual matrix. So at its highest, it would be a point that wasn't actually argued before the court in any event, and not that that particular decision is of great assistance where both parties, as we say, treat it as a needs case right from the beginning to the end. And also in that case, there was the added complication that the assets that had been acquired by the wife actually came from a family trust, which the husband's father had been involved in, which again may have added to complications as to how the ownership was involved. But if that's not correct, we say it's not a decision without law that should be particularly followed.
I'm just looking at the head note. Say that an award determined by reference to sharing would have been lower than that determined by...
Yes, it does, and that's found within the decision, I think paragraph 74.
Yeah. That puts it in a very different scale league, doesn't it?
At page 330. Where my Lord Mr Justice Moylan was, having not had any argument as far as we can see about sharing at all, simply says, if I were separately to determine what share of the wealth the wife should receive, absent the factor of needs or the application of the needs principle, the wife's award would be lower than her entitlement as determined by reference to her needs, and her needs was sub 50%. Although some cases seem to suggest that I must determine what my award will be by reference to both principles, I do not propose to follow this approach in this case because I have said I'm satisfied that my award determined by reference to the former, i.e. sharing, will be lower than that determined by reference to the latter, i.e. need. I think in that case, the actual outcome would have been pretty close to 50-50 because there were 3 very young children, and by paragraph 76, the school fees were then placed on the husband because he had 700,000 more capital. Their school fees, I think, even though they were then at primary schools or prep schools, were 40,000 a year, and they were very young. They were aged at the time 7, 9 and 12. 7, 9, 12, paragraph 6. So it would have been quite a long time to go. But in any event, that was leaving aside what doesn't appear to have been argued at all and dealt with on the basis of there was some separate property not invaded. The mutual marital property, if we came to that, would have given less than what the needs of it was. And we would say that's not going to provide a great deal of assistance where it wasn't actually argued, if our evidence is here. The husband puts forward essentially 4 main themes in his own presentation, which we can deal with very quickly. First of all, he doesn't put much store by the fact that he gave his money away, and he gave it away completely, legally and beneficially. He wants to restrict the application of matrimonialization. We have some sympathy with that, but on the approach that he adopts, that we would say would point to a matrimonialization of the assets. All assets have to become matrimonialized at some stage, and that wouldn't be of itself, we say, a reason to depart from a 50-50. They say that we have become bogged down in labels. That's wrong. We haven't become bogged down in labels. We've come to get this case within the principles which have now been established by at least 23 years of jurisprudence, which are tolerably clear. Now, it may well be that there are cases which are evidentially difficult, and my learned Lord Justice Moylan has referred to those both in XW and XH and also in Hart. But they're evidential difficulties. The principles that we've come to are fundamentally straightforward. They elide with the general law. They don't take the ownership of assets into a special and significantly different category. And those principles are simply this. There is a partnership which is entered into by the husband and wife. That partnership has an element of endeavour. There is fruit of that partnership. Both the fruit and the endeavour that takes place within that partnership ordinarily should be divided 50-50. There is then separate property. That separate property is capable of relatively easy definition. First of all, as a whole, it's out with the matrimonial. And then second, in terms of who owns it, that's normally pretty obvious. And here we have the finding of fact that the husband had completely divested himself of that property and it was now owned completely by the wife. His rescission claim, his mistake claim had failed, and so it remained very much the property of the husband and wife. And in those circumstances, it should only really have been invaded in a case of need. We say this case presents a real opportunity to achieve that level of certainty in how discretions might be exercised. And the fact that husband might regret paying some money to his wife in order to save himself 32 million is not really a good reason for departing from principle. The separate property principle is well engaged, as is the matrimonial property principle well engaged.
How is he saving himself 32 million?
There was you were talking about inheritance tax, i.e. he'd be dead at the
He's
time.
saving the wife 32 million.
Or
and the
saving his
children.
estate, 32 million.
Saving the family, really.
Well, it depends who he left it to, of course. But I mean, it's
We're talking here in real broad terms, aren't we? We're not. What is the purpose of this? What is the purpose of this disposition? It's to save on inheritance tax, which whilst technically for his estate's benefit, in the real world is for the benefit of his beneficiaries, who are likely to be his wife and children, at least in the main part.
Yes, that certainly would appear to be. We didn't go into the complete detail of the tax advantages and motivation from our point of view, because it wasn't actually necessary to descend into it to too great detail. But there was the husband's case certainly, and Mr Justice Moor was of the same view that the primary motivation was the tax saving.
The judge made very clear findings about it.
Yeah, absolutely. I'm not taking together, and I'm saying that embraced what the husband was saying too, and that was in the nature of inheritance tax. But the fundamental principle, and it applies as well in this case as in any other property matter as well, is if you give away your assets in a way that is determinative and there's no mistake and there's no rescission, you've lost those assets. And that is as significant when they're done between husband and wife. This is the post-1882 position that Baroness Hale refers to. Wives aren't in some pre-1882 position whereby if they receive the bounty of a third party, it's somehow diminished if that person is their husband, and that they're then put into an inferior position, that it's not.
So we keep on coming up across the same distinction, which is the distinction between the legal and beneficial ownership, which is clear cut. And as I understand it, the very different question is how a court will review those assets when it comes to consider Section 25
Yes.
division.
Yes.
You can say as often as you like that the husband has divested himself of ownership. That's a given here, as I understand it.
Yes.
The question is, what is the approach of the court to
Yes.
those assets
and
in the
what-
hands of the wife when it comes to consider how they should be divided up.
Yes, and what we say is the way that this court can bring certainty to this is to follow an approach which we say is supported by precedent, and that is if that asset came into the marital partnership, it should be divided 50-50. If it became the sole property of the wife, then it's only to be invaded in those situations where sole property is to be
We know
invaded.
here that the purpose of this transfer was to benefit the beneficiaries of the estate, and it would have been the husband's estate, but in due course, because of this transfer, it would be the wife's estate. But the assumption must be that those two things would be very much the same, and that the purpose of this transfer wasn't to divest the husband of a matrimonial interest, as it were, in the assets, but was to save the family.
Well, that's the
32
difference between
million inheritance tax.
well, that's the difference between his motive and what he actually did, and both of those are subject to the findings of Mr Justice Moor, and I don't seek to go behind them. The motivation was to save the tax, and the effect was it was no longer his separate property, and it was either the wife's or it was matrimonial property. We would say principled approach to property that finds itself in that way, starting with Baroness Hales, we start from a separate property regime and so on, is then, well, how do you look at that? And part of that concession that the wife makes is, we were all in together. I'm not going to run that deeply unattractive case, which she might have been able to run, which is, this is my separate property, you don't have a claim, it's tough on you, there it is. You can have half the matrimonial property, but that's it. Because she pays some recognition to that, but not because she has to. That's the difference. Because that's where
You are running the argument that it's separate property, and it's the foundation of your argument that that's only because of a concession that it should be shared equally that
yes,
it could be shared.
unless it's a matrimonial asset.
So it is at the centre, heart of your argument.
It is. So the concession that's made by the wife is an attempt by her to try and achieve an overall fairness that she believes should apply in respect of all of their assets, and hence the community of property approach that she deals with. But it in a principled and consistent way, it would either be it becomes matrimonial and divided equally, or it's the separate property and remains with her. The key part of it, though, is that the husband, for whatever reason, has now stopped it from being his own separate property. It has entered into either the mix of the matrimonial or, as I say, the separate property of the wife. And on a principal basis, there's then not a good reason to depart from it. If it was, as Mr Justice Moor seemed to find, that it was matrimonialised, and it was all matrimonialised, it's impossible to see how it would then be 40-60, or in fact it's a lesser degree than 40-60, because included within the 40-60 is Moundsmere and also the Ardenside Company, which were both pretty clearly supposed to be 50-50.
Well, I thought the justification for it is what Lady Justice Hale said, I think it's in White, that one of the things you look at is what is the source of the funds.
Well, the source of the funds at the time of the, and then called ancillary relief. So it's the source of the funds at the moment that it's before the court. And the source of the funds at the moment it's before the court is the wife, because it would have been open, as Mr Justice Moor correctly found, for the wife to have alienated all this money. And indeed, again, as Mr Justice Moor found,
That would be a very narrow view of the source of the funds, wouldn't it? The source of the funds, only 2 years before
3 years.
the proceedings started, or 3 years before the proceedings, but 2 years before the first letter was written, the husband had been the sole beneficial owner, and on this hypothesis had transferred them into the marriage. that seems to me transferred 77 million of his separate property. I'd have thought that is a factor which the judge was entitled to take into account on the authorities.
Well, it depends on what the nature of it is, because gifts between husbands and wives are not in some super special category of gift. And so what the effect of that would be was that an unimpeached gift should be reversed when it wouldn't have been reversed in any other
Well, the
circumstance.
point is, it isn't. The court wouldn't be treating it as a gift. The court would be treating it as matrimonial property.
Well, then, if it's matrimonial property, then it ought to have been part of the partnership. And what in those circumstances, when we're talking about source, then what we're talking about is sometimes referred to as contribution. The source is the contribution, and the cases on what is matrimonial property are clear that the ones that deal with the contribution are special contribution only, and they are beyond this. They are, as was accepted by the husband, not his case. So, in a nutshell, when the husband chooses, for whatever reason, it's not so critical what his reasons are, but when he does decide to either give it to wife, either independently to the wife or as part of the matrimonial partnership, he is walking away from an asset which had been his. And for that to then be removed from the wife requires a careful principled justification. If he, for example, he was very close to his brother and he did a similar scheme with his brother, which is, again, an entirely believable state of affairs, then no one would be suggesting that that gift could be reversed. So why...
No, but there isn't section 25 of the matrimonial
Exactly.
property Act.
Exactly. So if Section 25 is to be more than just an instrument of confiscation, it has to be on a principal basis. I think everyone's agreed on that. And that means, well, what is peculiar or particular about this? Because it was equally believable that to save tax, he could have moved the asset to a parent or a brother or someone else. And that would still have resulted in him not being able to retain it. In the facts of this case, what we say is his case at its highest ought to be, well, it became matrimonial. And if it did, it's 50-50. My lady, my lords, I don't know if I can...
Yes, can I ask you?
Yes.
I think you accept that title is not relevant to the categorization of an asset.
Title is relevant to whether it's the husband's separate property or the wife's separate property.
So it is title, it's not source.
For their separate property, it is title. Title will tell you who owns an item of separate property.
Sorry. Then how do we deal with wealth generated during the marriage, which is in the husband's sole name?
Husband, and so
That is separate property on your title analysis.
no. My lord asked, when was title relevant? Title is only relevant in the context of separate property. So money which is built up during the partnership is matrimonial money, and title is irrelevant to that. Title is relevant, though, to separate property. So if the husband acquires a great deal of wealth in respect of a matrimonial asset, it doesn't matter whose name it's in. That accrual will still be part of the marriage. But if he acquires a great deal of wealth on an asset which is in his sole title that was before the marriage, then that's his separate property.
So it comes back to whether the property is matrimonial or non-matrimonial.
Yes, it does. Yes, absolutely.
And your cases simply stated that if an asset is non-matrimonial and it transferred from one spouse to the other, then it doesn't become matrimonial. It remains non-matrimonial, but non-matrimonial in the hands of the other spouse.
Exactly.
Regardless of the source of those funds.
Exactly.
But not in respect of marital property.
No, because
if you transfer marital property from one to the other or put into joint names, it remains marital property.
because the marital property, and this is perhaps why there are 3 columns in the ES2, the marital property belongs to, in effect, the marriage, the marital partnership. It's the fruits of that partnership. So it's almost as if the partnership was like a limited company. It's almost like it has its own personality. Obviously, that's not right as a matter of law, but that's a good analogy. So an asset that is within the marital partnership, it doesn't matter whose name it's in at all. Because
why can't you gift your share of marital property just as you can gift your separate property?
yeah, you can gift your share of marital property, and indeed that's what the husband did here, because part of that £80 million was marital property, the $40 million US plus interest, less tax.
But on the argument, the answer you gave me, that should be excluded, and that should be included within marital property.
No, because the way that property can become non-matrimonial is in 2 ways. One is an express way, another one is inferentially. If it's unexpressed, if someone says, well, this was mine, this was my matrimonial property, but I now give it to you, I now take it away and hand it over to you, then they can make that separate property. In the same way that someone does with the post-nuptial agreement.
Title can be relevant to whether something is or is not matrimonial. So you can, as my lord just asked you, you can gift matrimonial property to the other spouse, so it's no longer matrimonial and becomes non-matrimonial.
You can gift matrimonial to the other spouse and make it non-matrimonial, yes. So you're giving up, if there was a bank account with £1 in, you give up your 50 pence.
So if you keep it in your own name, it's matrimonial, but if you gift part of it or all of it to the other spouse, it ceases to be matrimonial and becomes non-matrimonial.
If that's what your intention is if your intention
How do you define your intention?
Like the basis upon which it transferred. So the example that Mr Justice Moor gives in respect to the Arden Side land, for example, is if he transfers the property into the parties' joint names.
So you have to ask the parties, what was your intention behind this when you made this transaction?
You normally see
when
it by
you
the
set
title.
up the joint bank account, when you transferred the asset into joint names, you have to ask them what they intended?
Well, no, because you normally see it by what's happening with the title. So
you normally see it by what's happening in the title.
Yes. So
either that has a consequence or it doesn't. Are you saying transfer into joint names by itself, or transfer of a marital asset into the sole name of the other spouse, means it's no longer a marital asset?
It means it can mean that it's no longer a matrimonial.
So what additional factor do you need other than the transfer?
In most cases, you wouldn't need an additional factor. You would simply transfer. So you can transfer. Assets go out of marital partnerships all the time. There's no reason why it can't go to the independent person that is a husband or a wife, if that's what the parties are intending. And of course, ordinarily, the recipient would intend that as well. So that would be their mutual approach. And that's what happens whenever the parties enter into something like a post-nuptial agreement.
Sorry, you keep...
Well, that's important.
You're saying the mere fact of the transfer of a marital asset from the name of one spouse to the other will usually mean it is no longer a marital asset and becomes a non-marital asset.
If that was the underlying intention, yes. If there was a different...
It does require an intention. It's not just merely the transfer, it requires an underlying intention.
To move it from being a matrimonial asset to a non-matrimonial asset, yes, it would. Because if there was an intention...
Is this introducing clarity?
The circumstances in which it's going to happen are going to be fairly limited, and most of them will be clear because it'll be a question of, well, who owns this? And in most of the cases, who owns it is going to be tolerably clear. It's going to be either within the matrimonial partnership or not.
Can I postulate a different source of clarity? If you go back to paragraph 2 in Hart, where I set out the different formulations of what is matrimonial and what is non-matrimonial. And I take your point about a gift to the spouses together. So from a source external to the marriage, the financial product of the parties' common endeavour, the fruits of the matrimonial partnership. So one could say there are only 2 types of assets. The product of the marital endeavour, that will be marital property. Everything else is non-marital. Doesn't matter what the parties do, transferring it between themselves, tax reasons, other reasons, it doesn't matter. You only have two categories to make it simple and clear: marital property and non-marital property. Would that introduce clarity?
Well, the marital property also includes the fruits of the matrimonial partnership. And like any other partnership, you need to see what's actually gone into that partnership. So what has been introduced into it, and some of these things are going to be very difficult, could include to take the Jones example, the springboard itself, if that's a valuable company.
Because you see, at times you seem to be trying to run two rather divergent horses. You're saying this isn't a marital asset, even though its original source is outside the marriage, subject to your point about the mixing of it. But on the other hand, it could be matrimonial.
Well, that's the alternative argument.
I
yes.
understand, but your primary argument is this is not a matrimonial asset.
It didn't ever become matrimonialized. That's the primary argument, yes.
Because it was transferred from one to the other. The fact that it wasn't so if we stop the argument there and say that it didn't actually become your client's non-marital asset, but remain the husband's non-marital asset because it's from a source outside the marriage, is that another way of formulating a solution to the issues you've raised, which might introduce greater clarity?
No, it wouldn't be, and it would also introduce a huge degree of unfairness, because it would mean that if it's remained the husband's separate non-marital property, then it's as if the gifting of it, the unimpeached gifting of it, has moved to the wife. So what the court will have done is taken off the wife an asset which was hers in law for no very good basis.
But the basis is it's from a source wholly external to the marriage.
Well, then the question is, if it's been from a source wholly external, and again we've got the 40 million.
I put that to one side.
Right. Then it's a question of where has it been given to? And one thing we can say with certainty is it has not been retained by the husband. So that would result in either it's gone to the marital partnership, and I take on board what my Lord Phillips was saying about, well, did this go in the capacity to the wife qua wife? That might be an argument for saying it's marital, or alternatively it goes to the wife. But to wind back that transfer is to take the asset off of her for no reason other than these parties were married and she shouldn't be owning it. It's an elevation of the arguments about contribution, which one hoped had ended with White and Lambert.
Well, no, it's about source.
Well,
That's why I was taking you to the definition. It's source.
Source and contribution are often one and the same. Often, if not always, one and the same. And so that again becomes the critical factor, as the extent to which the parties have agreed that something should be given over to the other person, or alternatively given over to the marriage. Because the examples that my Lord is offering would put no store by that at all, not recognise what has actually happened here.
Thank you very much indeed, Mr. Tom. Yes, Mr. Bishop. Of course.
The wife's appeal in this case, we say, invites this court to bring into consideration two irrelevant matters, but fails to consider the most important and relevant matter. You're really invited to ignore the question of endeavour. You're really invited to ignore the question of source and ignore the question of whether or not wealth is the product of endeavour which took place within the partnership or outside the partnership. But instead, we were asked to look at questions of legal and beneficial title. And as I'll come on to demonstrate in a little while, we say that that is completely irrelevant to the proper consideration of the search for fairness by reference to the sharing principle. And you are asked to consider autonomy. The wife does not contend that how the assets were held at the end of this marriage should actually be what the court should have ordered, but rather that there should have then have been a redistribution in line with a concession. There was no agreement in this case at all. There was certainly nothing agreed in relation to what should happen were these parties to divorce. The presentation of legal principles that is found in my learned friend's 3 notes and in his submission today, I just don't recognise at all. I refuse to accept that the process in which the court is engaged in applying the sharing principle is anything like as complicated or as abstruse as he suggests. What it comes down to, and we'll see this in White, Miller, Charm and Hart, and also Waggard, is that there should be the division of the fruits of the partnership. That's the key message. Not the division of everything, whether or not they're the fruits of the partnership, but the division of the fruits of the partnership. The reason why each party will normally receive a half share of the fruits of the partnership, because that has been generated during a period when they were making common endeavour equally valuable in the eyes of the court, be that money-making or domestic. And the reason why you don't share the wealth which is generated outside the partnership is because that is the result of the endeavour, the work of one of those parties only. It will be, I think, of assistance to go back to the foundation passages in Miller just to see how it is put by Lord Nichols. Can I ask you in the authorities bundle to go to page 17, please? Your ladyship will have known from reading Miller many times that it is replete with references to fruits of the partnership, fruits of the party's common endeavour. And so if we start on, page 18, let's look at paragraph 16. When their partnership ends, each is entitled to an equal share of the assets of the partnership unless there is a good reason to the contrary. Paragraph 17 goes on, final line. In the nature of things, this will affect the quantum of the financial fruits of the partnership. Paragraph 19. To confine the wide approach to the fruits of a long marital partnership would be to introduce the sort of discrimination. Paragraph 20. The decision of Mumby and P&P regarding the family farmers instance, for business and investment assets can be the financial fruits of a marriage partnership as much as family assets. Paragraph 21. The complication with it said, I referred to the financial fruits of the partnership. Over the page, last line, matrimonial property means the matrimonial home plus property acquired during the marriage partnership other than by gift.
Sorry,
or
where was that?
sorry, bottom of the page 18, so that's still within
21.
paragraph 21. Matrimonial property means the matrimonial home plus property acquired during the marriage other than by gift or inheritance.
That's a different formulation, isn't it?
I don't think it is intended to be,
No.
my lord. It's saying there the same thing, that the fruits of the partnership will be what is generated by the parties' endeavour during the marriage partnership. That's what the fruits are. And the reason why they are shared and why we have this definition of matrimonial property that comes in is because that derives from their endeavour, their common endeavour.
But it may not be an endeavour, might it? You might acquire property not through any endeavour.
Well, if you acquire it from an external source, then that would not be the fruit of the partnership, because that would be external donation. What does your lordship have in mind?
What if one of the couple's parents makes a large donation to both of them to help buy a property?
Well, that would be a source external to the marriage. That would be non-matrimonial property. Of course.
Even if it's given to both of them jointly.
Yes, my lord, that would be a source external. I mean, it might be argued that that gift of both of them might be come within the notion of matrimonialization.
They're buying their first home.
Yeah.
They've raised 100,000, and one of the parents of one of them donates 100,000 to contribute to purchasing the property in their joint names.
That's the sort of
as an
case
express gift to both of them.
That's the sort of thing we encounter quite a bit, and the argument in there would normally be that this constitutes a contribution, an unmatched contribution from one party because it comes from a source external to the marriage.
And it doesn't become matrimonial property.
Well, it could do in the process of matrimonialization, and it might be that a court sees that that is something that leads to the fact that it's to them both, that might lead to it being seen in a different category, although I would say matrimonialization is a concept that's going to have to be very carefully constrained. But if your lordship is conceiving of an idea, that doesn't derogate from the fact the main purpose here is to look at wealth generated during the marriage partnership by the parties.
From endeavour.
From endeavour.
What if they buy a lottery ticket?
One of the cases deals with a lottery ticket, actually. And in terms of a windfall, Mr Justice Mostin said in S&AG, yes, that doesn't fall into matrimonial property because that isn't by nature of funds generated by endeavour.
But even if they buy the lottery ticket together, why isn't that an endeavour?
Well, that might be a windfall to them both, so they'll each be entitled to half of it. But endeavour's right at the heart of it. Endeavour is right there, and the danger here is attaching the label of matrimonial and non-matrimonial without linking that to questions of endeavour. And we'll see both in Miller and in Hart, it comes down to when was the endeavour undertaken that generated the wealth. And that's another way of looking at the question of source. And so going back, my lord, to paragraph 23, paragraph 22 on page 19, there's a real difference, a difference of source between property acquired during the marriage otherwise than inheritance or gift, sometimes called the marital request, but more usually the matrimonial property and other property. So that's the distinction identified in the House of Lords in Miller. I'm going to just quickly take you through the other references as well. Paragraph 23, the matter stands differently in regard to property the parties bring with them into the marriage or acquire by inheritance or gift during the marriage.
Sorry, where's that one?
That's paragraph 23, my lord. And then over the page, paragraph 26. Before that, I just refer paragraph 25. With longer marriages, the position is not so sure. Non-matrimonial property represents a contribution made to the marriage by one of the parties. We'll come back to this later on, but this deals with the point my learned friend says. He says, well, any contribution that you take into account has to be a special contribution, otherwise that's discriminatory. Not so. The introduction of non-marital property, bringing that into marriage, that is an unmatched contribution per paragraph 25 of Miller. And then over the page, flexibility. The difference in treatment of matrimonial property and non-matrimonial property might suggest that in every case, a clear and precise boundary should be drawn between these two categories of property. This is not so. Fairness has a broad horizon. And sometimes in the case of a business, it can be artificial to draw a sharp dividing line. Paragraph 27. Accordingly, where it becomes necessary to distinguish between matrimonial property from non-matrimonial property, the court may do so with the degree of particularity or generality appropriate to the case. We'll come back to that. the judge will then give the contribution made by one party's non-matrimonial property the weight he considers just. It's also, of course, in the judgment of Lady Hale. Could you turn, please, to page 45?
Sorry, can you give me that again?
Page 45, paragraph 141. A third rationale is sharing of the fruits of the marital partnership, matrimonial partnership. Over the page in 143. Do you have that? Sorry, my lord. It's right, the first line.
Trying to.
Appreciate that
Yeah,
this is
sorry.
rather.
No, you're going quite quickly. Thank
Yeah,
you.
sorry.
That's all right. Yes.
Over the page 46, please, 143. There are many cases in which the approach of roughly equal sharing of the partnership assets. And then a few lines down. Although one party may have earned more and thus contributed more in purely financial terms to the acquisition of those assets, both contributed what they could. And the fair result was to divide the product of their joint endeavours equally. There's reference to partnership again in paragraph 144. And then can I just finally take you to paragraph 49.
Paragraph.
Sorry, I beg your pardon, page 149, paragraph 149 at the top of the page. The fruits of the marital partnership. And that's picked up again on page 50, 154. Both sharing of the fruits of the marital partnership. This, of course, then, I mean, it's dealt with, as I've said, in Charman, but I'm not going to take you through those references there. For your note, it's paragraphs 64 and 66. But can we have a quick look at Hart, please? And Hart, we say, is the true successor to Miller in clarifying these concepts. And what is said there at paragraph 2 is this.
Sorry, one minute.
That's at 256.
Yes, hold on. My highlighter is not working quickly enough. 256. Yes.
In this judgment, I use the words matrimonial and marital interchangeably. White and Nichols have both used the expression from a source wholly external to the marriage when referring to non-matrimonial property. He defined matrimonial property in McFarlane, Miller, as the financial product of the parties' common endeavour. Whereas Hale used the expression fruits of the matrimonial partnership. And then there's reference to Charman. And then this is picked up again, of course, in paragraph 67. On page 266. The exercise on which the court is engaged in applying the sharing principle in this context is therefore to determine whether the current assets owned by the parties or within the scope of section 25(2)(a) comprise the product of marital endeavour. The court must then decide how that determination should impact on the court's award. And the classification, I'm not going to read it out, you've looked at this already, but it goes back to the preceding page 62 through to 66, make the same points. And then your lordship goes on at paragraph 86. To say that it can be artificial to attempt to draw a sharp dividing line. You say that you don't accept that there is a real difference between the differences of approaches that have been adopted in relation to this question in the cases. You say one application may be more specific or may reflect a degree of particularity or generality appropriate in the case. And then I may finally just deal with paragraph 96, and we say that this is very important indeed, if the court has not been able to make specific factual demarcation, has come to the conclusion that the party's wealth includes an element of non-matrimonial property, the court will also have to fit this determination to the Section 25 discretionary exercise. The court will have to decide, adopting Lord Justice Wilson's formulation of the broad approach in the Jones case, what award of such lesser percentage than 50% makes fair allowance for the party's wealth, in part comprising or reflecting the product of non-marital endeavour. All of these foundation passages, my lady, establish that sharing takes place in respect of the fruits of the partnership, that is to say, the fruits of the party's common endeavour. But if the wealth is not the product of common endeavour, then that should be identified and left out of the sharing process. You will have seen that in none of those passages that we looked at there is there any reference to the relevance, the question of title. The court is not engaged in the process of inquiring why a party may hold an asset or not. It's about assessing when it was generated, by who. Was it by common endeavour or was it not? Now, my learned friends have filed 2 documents before Mr Justice Moor and 3 documents before this court. And in none of those documents do they undertake any analysis of what the fair outcome of this case is by reference to the party's endeavour. And this is the elephant in the room as far as they're concerned. Because if you were to assess what's fair for the wife to receive because of her endeavour in relation to the £80 million transferred in 2017, she would have to concede that she played no part in its creation and that overwhelmingly this was the product of the husband's sole endeavour before the marital partnership began. Now, I hope you don't mind if I just remind you of some of the facts in relation to this £80 million, just so that you have them clear in mind in terms of your knowledge, your understanding of what that money comprised. Could you turn please to page 128 in the core bundle? At paragraph 63, Mr Justice Moor said this, about 2/3 of the way through the paragraph. Mr Bishop has taken me through his client's detailed disclosure, which certainly appears to show that on the 30th of June 2004, the husband had assets of $139,648,065 Australian dollars. Could you go on, please, to page 134?
Sorry, what paragraph?
Paragraph 81.
Thank you.
I'm just going to take you through paragraphs 81 to 83. I've already decided that the land at Arden side is not matrimonial and must be excluded. This reduces the total to 112 million. I must then decide how these matrimonial assets should be shared. I'm quite clear that there should not be an equal division. I found the transfers amounting to some 80 million to be matrimonialised, but they are most certainly not matrimonial requests in the standard sense that they were not all earned during the marital partnership. To a significant extent, this money was pre-marital and has only been matrimonialised towards the end of the marriage. I would not go so far as to say that the assets are only matrimonial as a result of a technicality. There's no doubt the husband intended to transfer them to the wife, and he could not reverse any benefit to himself. Equally, however, I cannot ignore what Mr Bishop calls the magnetic factor, namely the pre-marital origin of most of this sum. And then over the page, he deals with what his wife was saying, that it contains some marital earnings. 83, I find it almost impossible to say what proportion of the 80 million was earned during the period. I accept the husband started work in 1972, some 32 years earlier. I do not, however, take the view that a day worked in 1972 is equal to a day worked in 2004. And then it goes on to say the husband's earnings in 1972 would have been minute compared to his earnings in 2004. And then he says, all I can do is say that I find that a part of the sum of 80 million is money that was earned during the marriage. Whilst the wife would be entitled to an equal division of that money, it is impossible to quantify it accurately. Now, the wife was saying below, and I said again before this court, that she thought that was about 40 million. On exchange, $40 million. On exchange rates, deducting relevant tax, that would be about £13 million. Three other things just to show you, if I may. Please go to paragraph 73. And this is, we say, a very important pointer to the scale of, page 131, paragraph 73, my lord.
Paragraph 73, thank you. Yes.
6 lines down, 7 lines down. If this marriage had broken down 6 months after it had been celebrated, this court would undoubtedly have dealt with it on the basis of needs, albeit with additional consideration for what the wife had lost in terms of entering the marriage. She could not possibly have mounted a claim to share equally in the husband's premarital wealth. Indeed, I am clear that this remained the position immediately before the transfers to her in early 2017. And so what the judge is saying there is that up to the transfer, this was still a needs case. And the only reason for that was because of the scale of the husband's substantial premarital contribution. Can I show you 3 other references, please? Would you go, please, to page 70 in the court bundle? 71, sorry. This is part of our skeleton argument. And here at the table at the top, you see what the actual premarital contribution was, broken down. And you see that it came in 2004, it came to 57,255,706. Back in 2004.
Sorry, wait a minute. Oh, I see. This is all of it. Sorry, I thought it was...
That's everything that he brought in.
Yes.
It became £80 million, that were then, 77 million that were then transferred. And the judge found that an element of the increase from 57 to 80 were some laid up earnings.
Wait a minute, this includes the Ardenside station.
It includes Ardenside Station.
Which is not in the 80 million.
That is not in the 80 million.
So
Correct.
the 57 doesn't become 80. So
You
it's
deduct 3.7.
And does it include the property in Melbourne? I'm just trying to work out.
Well, it includes the husband's property in Melbourne, not the property in Melbourne which belonged to the wife, which then
This one, this is his.
yes,
Right. Okay.
this is all his. It does include Ardenside, but of course Ardenside was premarital, so that was part of his 50.
I know. It was just, I thought you were comparing it to the 80, and this
Yeah,
is
that's a completely fair point. Sorry about that. Can I take you to 2 other documents, please? And that is, would you please look at in the supplemental bundle? Could you turn to page 5 in that? And what the husband does in this table, to orientate, this is part of one of his early statements in the case on the 23rd of November 2020. From page 5 through to 7, you can see the career, and the career that led to the accumulation. You can see here the premarital endeavour. That's what it was. And the fruits of the premarital endeavour were the £57 million. And then finally, on this theme, could you go in the supplemental bundle, please, to page 86? This was part of the documents that the wife filled in when they were putting together the plan to put money into trust. Please look at the comment when it says source of funds.
Mm-hmm.
The funds to be placed into trust were generated by my husband, Clive Standish. Clive accumulated his wealth over a long career at UBS through salary and bonuses. These funds were then invested into various ventures, most of which have generated returns. That was the statement made by the wife in connection with the setting up of the trust in 2017.
It was gifted to the wife. It was gifted to the wife.
It was gifted to the wife.
Yes.
Yes, and so when Mr Justice Moor made the decision in this case, those funds were in the wife's title. The title is irrelevant to the consideration of fairness. Even though they had been gifted to the wife, they were the product of the husband's premarital endeavour. And as such, they fell to be classed as non-matrimonial property outside the sharing principle.
Well, except that's right, but even somebody who earns from premarital endeavour retains autonomy to dispose of those assets as they see fit.
Well,
and Mr Standish had chosen to transfer them to his wife.
and in every marriage,
And you say that wasn't by way of adding to matrimonial property.
yes, absolutely,
It remained separate property,
absolutely.
and it was now the separate property of the wife.
No, because it wasn't the, well, my lord, that's because what is separate property is a phrase which isn't of any help. What is non-matrimonial property? Non-matrimonial property is money that is earned and generated outside the marriage partnership. That's the definition of it. And
Well,
that's,
according to you, now it is, because the wife had generated or received that money from the husband outside the marriage.
she didn't receive it outside the marriage, my lord, sorry.
What are you saying? You're saying
I'm
you're
saying
saying
that-
this isn't. These aren't assets acquired as the fruits of the marriage. They were assets acquired by a transfer.
They were generated by endeavour before the marriage to an overwhelming
And
extent.
transferred to the wife.
Transfer to the wife is irrelevant because, my lord, title is irrelevant. You can have lots of cases where things are held in one name, another name, for tax purposes, for other purposes, and the courts look through that and distribute the wealth by reference to the question of is this matrimonial or non-matrimonial property, and that is defined by was this generated by common endeavour during the marriage or by premarital.
You'll take us on to this, no doubt.
Beg pardon?
You'll take us on to this, no doubt.
No, that's what we've been through, my lord. So when we looked through Miller and we looked through Hart, the definition of matrimonial and non-matrimonial property is the expression of was this generated during the marriage by common endeavour or was it not?
But what I haven't seen, it may just be my misunderstanding. and lack of
I took it
familiarity
at
with
quite a
this area.
lick, my lord. Yeah.
But what I haven't seen in anything you've shown me is that when you determine that something isn't matrimonial property, the court can then say, well, although it belongs to wife, it should be treated as the asset of the husband.
But that's mere title. And we will look at a case where that happens.
But title is more than just title. It's whose non-matrimonial property is it?
Quite wrong, my lord.
Well, I'd like to see some
with the
authority for
greatest possible respect. That's absolutely wrong. And that's the fallacy.
That's the
my
purpose of this exercise. So
Well, that's the fallacy that my learned friend puts forward, which is, oh, well, you can have something that was someone's non-matrimonial property and then become someone else's non-matrimonial property. That's a complete impossibility.
That's what happens with property.
Well, that happens with property, but this isn't a proprietary
Well, you have to,
inquiry.
for my
This is-
purpose, you're going to have to show me that.
Yeah, this inquiry, my lord, and the purpose of the divorce proceedings
Yes.
is an exercise in fairness applying section 25.
Yes.
And the route to fairness is found to be, in connection with the application of the sharing principle, regarding some assets matrimonial, some assets are non-matrimonial. And the route to that is when they were generated.
Can I say, forgive me if this is too simplistic, but I always take as my starting point section 25. And my understanding of section 25 is that what it entitles the court to do is to adjust the part of the property. And the starting point of any adjustment, as indeed we see from this order, is a requirement that one of the spouses may have to transfer some of their assets to the other spouse.
Yes.
So the starting point is determining whose assets are they as a matter of law.
Well, that is, yes, that is the
And then in the court's discretion as to how that should be done, the court determines whether or not they are matrimonial assets in order to that those would be subject to a sharing. If they're not matrimonial assets, the court will generally not interfere with the legal ownership of those assets.
Well, you're right, my lord, to say, if I may, you're right to say the starting point is to look at all the wealth that's there and to identify as a matter of fact so that it knows who is transferring to whom, in whose title that wealth is.
Yes.
Whether it be husband, wife, or thing, or in joint property. Sometimes, actually, resources are found to be belonging beneficial only to third parties as well within the concept of resources. Okay,
Yes.
so that's the starting point.
Yes.
But then, my lord, the court then divides that wealth into matrimonial and non-matrimonial property.
Yes.
And the matrimonial property will be shared equally, subject to good reason why not. And I'm going to come on to the question that this has to automatically be divided 50-50. But the non-matrimonial property will remain with the person who generated it.
Well, that's the proposition that I would like to see some authority for, that the person who generated it rather than the person who owns it.
But that's what is said in Hart, my lord. Because what is said, the court's task here is to make a fair allowance for within the sharing principle for the fact that some of this wealth has not been generated during the marriage.
My lord will understand that much better than I do, but I didn't read from Hart that it had any consideration of a situation where one person had originally generated, but then had transferred title in the asset to the other part.
But my lord, if I may,
but not by way of adding to the matrimonial assets.
If I may,
Yes.
matrimonial and non-matrimonial are just labels. They're just labels,
Yes.
and as you, I think, Sir Orchard rightly said at the beginning, there are labels there which are legal constructs and have no particular independent recognition within the statute.
Force of a statute. They're not.
And they're not. But all matrimonial property is that which is generated during the marriage. And all non-matrimonial property is that which is generated before the marriage or received by way of inheritance.
But what your
And so-
proposition seems to be is when the court makes an order under section 25,
Yeah.
and it determines property is not non-matrimonial property, it can not only make an order. It can make an order that the owner of that non-matrimonial property transfers it to the non-owner of the matrimonial property.
The owner of
Authority.
that particular asset can transfer it to the person who earned the money. Yes,
Yes.
absolutely it can.
Okay. Well, at some point you'll show us the authority, and that will be helpful to me.
I would submit is absolutely clear from the authorities we already looked at, but it's obviously not sufficiently clear for your lordship. So I'll give some thought overnight.
I'll look at them again.
No, I'll give some thought overnight about actually trying to find a specific reference that which might give things. But can I just say this suggestion, and my learned friend Mr. Todd said this. Oh well, it was his non-matrimonial property, but it became her non-matrimonial property, that's a nonsense, with great respect to him. Because it's his non-matrimonial property because he generated it before the partnership. It can't then be the wife's non-matrimonial property because she can lay no claim of generation in relation to that wealth.
Are you saying it's legally impossible for one party to a marriage to transfer their non-matrimonial property to the other?
No, you can
What if
you
they
can
want-
transfer it as a matter of title. But if you want something that's going to be respected on the application of the sharing principle, in accordance with Miller and Hart and Charman and all those authorities, that could only be done by reference to a nuptial agreement. Without that, if you just then have the ordinary principles of law, what will then happen is the court will undertake the inquiry. What's the source of this money? Who generated it? When was it generated? And undertaking that, once it's made that assessment, the money will follow the generator. I'm sorry if I've sort of...
No, it's very interesting.
I'm sorry if I've sort of put that too bluntly. I don't mean to, but I mean that is English law.
Thank you.
The wife, we submit that the attack on this judgment is fatally flawed by the fact that the wife ignores the most important factor, and that is inevitably going to be a substantial departure from equality in favour of my claim, because it was quite impossible to say that 132 million, or indeed 112 million, were the fruits of the partnership, the fruits of common endeavour, or anything other than to a huge extent the product of my client's endeavour alone before the partnership began. And Mr Justice Moor recognised this. We say he didn't go far enough, but he recognised this at 132, where he says the source of the funds must and does remain a very significant feature. That's in paragraph. Sorry, that's in paragraph 75, about 8 lines down. The source of the funds must and does. As your lordship, as my Lord Justice Moylan said in argument with my learned friend, the good reason for departure from equal sharing of matrimonial property is source. And we see that in 6 different cases. So if there's been a process of matrimonialization, we dispute whether that's happened in this case, but we'll come on to that tomorrow inevitably. But if there has been matrimonialization, we say it's perfectly legitimate for there to be, as a good reason for departure from equal equality, consideration of source. My lady, we say that the wife's failure to look at endeavour, to factor in endeavour, when and by whom wealth was generated, provenance, has led her into making some pretty strange suggestions in the written material, because she has said the provenance of the 77 million or 80 million was in fact the wife, because it was in her name just before the divorce. But that defies all logic. This wife had nothing to do with the generation of that fund. How can you say this was a contribution from her? So this is the sort of intellectually contortions that have to be undertaken. She also says at one stage, well, I'm in the position of someone who's received an inheritance or a gift, albeit it's a gift from my husband. It just doesn't work. When the House of Lords, the Court of Appeal, are talking about gifts and inheritance, they're talking from external sources, not how within a marriage title ends up. And so again, we say that this just goes to show how it is clear that this wife cannot bring herself within the authorities to demonstrate that she has a good sharing claim in relation to this money. And we say that she's tied herself up in knots in relation to that. I'm not going to go through all the other ways in which we say actually her presentation just doesn't work in terms of acknowledging or failing to acknowledge endeavour. Right, my next subject, I think I can probably get through in the time available, it is the irrelevance of title. And we say it's a fallacy at the heart of the wife's case, that if property is held in one party's sole name, that is a relevant factor to how it should be shared. Plainly, who happens to be the legal and beneficial owner of property at any given moment is not indicative of how that money was earned. It's not indicative of whether it was earned inside or outside the partnership. That's a proprietary exercise. It's not the exercise undertaken in the search for fairness on divorce under the Matrimonial Causes Act. We say Mr Justice Moor's approach to this point was very sound. And if you go to 132, at paragraph 74, he's absolutely right about this. He says, I do, however, this is halfway through the paragraph, I do, however, reject the suggestion that this money became the wife's separate property entirely free of any claim by the husband other than on a needs basis. It has long been clear in this jurisdiction you cannot benefit from keeping assets in your sole name. The obvious example is the moneymaker, who generates significant assets during the marriage but keeps them in his sole name. The homemaker's claim to share those assets is just as strong as if he had placed them in joint names. In the same way, if a moneymaker transfers assets earned during marriage into the name of the other, the moneymaker can still make a sharing claim against those assets on marital breakdown. That's the point. That's how it does that. We say that that's spot on.
Well, as I understand it, the parties are in agreement that these are not matrimonial assets.
Well, the wife says they're not matrimonial assets and they should remain with her. The husband says they're not matrimonial, they should be
But
returned.
also, as I understand it, the difference between you, you both agree they're not matrimonial assets. The difference between you is the effect that the transfer from the husband to the wife had on the approach of the court to the non-matrimonial assets.
Yes, and so what, I don't know if there's necessarily a difference between us on that, but what Mr Justice Moor found was that the transfer was an act of matrimonialisation, if you forgive.
You both appeal that.
Yes, we say that that's all right, but also we address the consequences of the court rejecting our appeal on that and considering that matrimonialisation did take place,
Yes.
whether then he exercised his discretion fairly. But we will say that, and I've got submissions made to you tomorrow about whether or not making that transfer did constitute an act of matrimonialisation, and we'll have to look at what matrimonialisation really means. But I can perhaps just trail this point, that given that matrimonialisation involves treating as the fruit of marriage something that was not generated during the marriage, and is a derogation from the fundamental principles that there should be the sharing of the fruits of the partnership generated during the partnership by common endeavour, any derogation from that must be conservatively and cautiously applied. And that's be part of my submissions tomorrow. That's point. But anyway, just coming back to the irrelevance of title, my lord. We say that the observations there at 74 are absolutely right. And actually, the attempt to reintroduce title as a significant factor is really an attempt to turn the clock back to how this court, approached the case of White and White. Your ladyship will probably remember that in that case, Lord Justice Thorpe in the Court of Appeal was very drawn to the idea of a detailed.
Suggesting I'm the oldest here and
No,
have this recollection.
No, no, I'm sure everyone will recall. He was drawn to the idea of a detailed inquiry into the legal and beneficial interests of each of the parties in terms of the partnership. And then it went to the House of Lords. Can I ask you to turn in the bundle, page 416, the authorities bundle?
Sorry, I don't have it.
Do you have 416?
No, I don't.
Ah,
I go from 400 to the now.
then,
Have you?
yeah, well, apologies for the absence of that.
Not at all. Mr. Harvey seems to have a supply of nearly everything we're likely to
Yeah,
need.
wisely, he's...
I've
Thank
got
you.
it.
Have you got it?
Yeah, I've got it. It's really one.
It does find its way to me. Have you got it?
Start at 42.
Thank you, Mr. Harvey.
I've got it.
I can do.
My lady, it's page 611 of the decision.
So page.
611. In our paginated one, it's 416, but in the internal paginated, 611, my lady. And starting to read at D. That's appellant counsel. His next criticism was that the members of the Court of Appeal placed undue emphasis on the financial worth of each party on the dissolution of the partnership. This was a wrong approach, as was the view that the court should not exercise its statutory powers unless there was a manifest case for intervention. I agree that both Lord Justice Thorpe and Lady Justice Butler did attach considerable importance to the wife's entitlement under the partnership. Their observations, particularly in the judgments of Lord Justice Thorpe, which read by themselves might suggest that in this regard, the clock was being turned back to the pre-1970 position. Then courts often had to attempt to unravel years of matrimonial finances and reach firm conclusions on who owned precisely what and in what shares. The need for this type of investigation was swept away in 1970 when the new legislation gave the court its panoply of wide discretionary powers. Since then, the courts have not countenanced parties incurring costs which would be disproportionate to the assistance the expenditure would give in carrying out the Section 25 exercise. All this is well established, so much so that I cannot believe that either Lord Justice Thorpe or Lady Justice Butler intended to gainsay this approach. Indeed, Lady Justice Butler stated expressly that what she had in mind was where the parties were in business together was a broad assessment of the financial position and not a detailed partnership account. She rightly noted that even in such a case, the parties' proprietorial interests should not be allowed to dominate the picture. If Lord Justice Thorpe went further than this, he went too far.
Basically, that's addressing matrimonial assets, isn't it?
That's addressing,
Matrimonial assets.
that is addressing, yes, whether or not within the process of assessing matrimonial assets or the assets, it is relevant for there to be extensive inquiry into what the legal and beneficial interests of the parties were.
Yes.
Swept away.
But forgive me, I think the point I'm making is I'm not sure that it's been suggested here that you don't look at legal entitlements to non-matrimonial assets.
But there's no justification for doing it in relation to non-matrimonial assets as opposed to matrimonial assets. There's just would be no logical basis there. In relation to all the assets, the courts look past title. That's what they do. They look at generation. The exercise of working out quantum pays no regard, my lords and lady, to whose name the assets are in. At no point did Mr. Miller even suggest that the fact that all of the assets were in his name was of any relevance at all. And my lady, this is the common experience and practice of financial remedies today. Day in, day out, courts simply compute the fruits of the partnership without any reference to title at all. If a party could claim that an asset was outside the sharing principle because it was held in their sole name, this would create a terribly unfair advantage for wealth generators who can elect to keep their wealth in their sole name, as Mr Justice Moor said in paragraph 74. And what's more, it's completely impractical to get the courts to look in every case as to the background of why assets are held in a particular way. This could lead to severe hold-ups in dealing with fair sharing in so many cases. Can I take you to two other authorities where one can see how legal title was something that was seen as being irrelevant? Could you go to please to the case of JL and SL at page 354?
Sorry, could you give me that again?
354, it's paragraph 19. The fact that there had been some mingling of monies, in the sense that some of the monies had been placed in the husband's name, does not, as the authorities demonstrate, specifically my own decision of N&F, to which I refer, mean that the non-matrimonial source of the monies in question is destroyed as a relevant consideration. Far from it. In the decision of N&F itself, the non-matrimonial contribution was made many years earlier, and in comparison to this case, was nonetheless reflected in the decision which I made. So there was a case where the wife received an inheritance, she put a large part of it in the husband's name. The husband tried to say that that meant that she could no longer assert, because the title had passed, she could no longer assert her non-matrimonial property route in relation to this, and it was rejected. And we know that the entirety of that non-matrimonial contribution was then returned to that non-matrimonial money was then returned to the wife. That's what happened in that case.
Can we just look at the facts of that case in a little more detail? What were the resources?
The resources in that case, my lord, in 348. Well, we know that the inheritance was 465,000, and 190,000 was put into the name of the husband.
This was an appeal, wasn't it?
It was an appeal, and then and then it went through another twist, because if you see the next tab, the whole thing was set aside because the husband then received some money from the sale of a company. So the whole thing was looked again, and that was JL and SL number 2.
Anyway, this. So it was the wife had received 465 from her mother.
Yeah.
And where do we see what happened to the asset during the marriage?
Just, well, 100. If you look at the head note on 348, 190,000 of the inheritance was put into the name of the husband, which the wife claimed was due to his account receiving better rate of interest, and to allay the husband's fears that if the wife died suddenly, he would be unable to access money held in her name.
Paragraph 10 sets out the details.
Paragraphs 14 and 15 deal with the background to the transfers. And what Mr Justice Mostyn said there is the placement of the money in his name or her name, at least on plain reading of the words, seems to have nothing to do with any underlying decisions by the parties as to whether such and such fund should be characterised as matrimonial, with the concomitant consequence of equal division on divorce or not. And
well, it's not clear to me why she wouldn't have retained a beneficial interest in that.
why she would not have retained a beneficial interest.
Yes.
Yes, because it was, well, I think it was placed in his name, he wasn't under any restriction in terms of what he did with it. He wasn't holding it as her nominee. He was holding it there for him to use in the case of something happening to him, no, to her.
It seems it was for two reasons. One was
Interest, better rate of
better
interest.
and the other was in case she died.
Yeah. Well, I mean, that's an arrangement that they made within that particular family. Or they saw that as having some sort of purpose.
So was there a finding that she didn't have a?
Can I check that?
title?
I'll look at that and we'll check whether or not there was a finding, whether or not there was actually a disposal both of her legal and beneficial interest, or whether it was simply placed in the husband's name.
Well, yes.
I will check that because I don't want to.
Well, there's no presumption of advancement, is there? And if the husband didn't give consideration for it,
No.
so on the face of it, he would have held it on a nominee or a bare trustee, I'd have thought, wouldn't he?
Okay.
I don't know. It's unless it.
I'm
not sure it's an example of monies which had been, in which title had vested in the husband, or full title.
Well, certainly legal title was,
Legal
because
title.
but whether or not there was some retention, I don't think, from my recollection of reading the terms of that judgment, that there was a debate, there was a sort of an examination of the beneficial situation.
I don't think the point was taken in that way.
Sure, but the point is that notwithstanding the fact that it had been moved into the husband's name, nevertheless, the fact that this was all of the £465,000 worth of inheritance was credited to the wife in terms of retention, in terms of noise. And so to deal with your Lord Justice's point, that is there an example of something being transferred back if it's sort of left someone's legal title in order to do justice in connection with the application of matrimony or non-matrimony? This probably is such an example. Can I just look at one other?
Well, the fact that the reason the judge addressed it the way he did was not to do with beneficial ownership. It was because he decided the non-matrimonial source of the monies had remained of relevant consideration. That's what he sets out in paragraph 19.
Yes, and that's, I know the sums are completely different, but that's completely relevant to this case. So we say there's nothing to disturb the significance of the provenance and source of the money in this case, even though, as they went into the hearing, it was in the wife's name, because the inquiry is as to endeavour. I've made those submissions. Can we look at J and J? I don't think my learned friend has properly characterised this. It's right that the wife got 46% of, I think, £9 million. Your Lordship may have some very vague recollection of this case. But this was a case where the husband had made a very substantial unmatched contribution. And we get that, my lord, from page...
It's
Tab 10.
tab 10, thank you.
Yeah, it's 3... Could you go to 323? Contributions. Both parties made full contributions during the marriage. 48. The husband has, in addition, made a significant financial contribution through his premarital wealth. Now, what had happened, if you go back kindly to 315, is that at the time when the matter came before the court, the wife was in fact holding 60% of the total assets in her own name. And the reason for that, you can see on page 317 at paragraph 9. In December 2006, the company was taken over by Schneider with the family trust, receiving 26 million gross. Capital gains tax of 2 million was paid. Advantage was taken of the wife's non-domicile status to reduce the tax, which would otherwise have been payable by a significant distribution being made to her. So you have a situation there whereby 60% of the money was in her name. It was done. to mitigate tax. Nevertheless, my Lord Justice Moylan identified that the husband had made a significant financial contribution through his premarital wealth. And then finally, at page 7, paragraph 74 on page 330, if I were to separate or determine what share of the wealth the wife should receive, absent the factor of needs or the application of the needs principle, the wife's award would be lower than her entitlement as determined by reference to her needs. And that has to be as a result of the husband's premarital contribution. So here we see illustrations of how the fact that it was in the wife's name, the fact it was in the husband's name in jail and SL, is held to be irrelevant to the operation of the sharing principle by reference to premarital assets. Now, what my learned friends have done, I think I can take this pretty quickly, is refer to paragraphs 153, 170 in Miller and say, look, there's relevance ascribed to separate property there within those comments. You know the comments I'm talking about. But as was stated, and it's these are references that are made repeatedly throughout their skeleton arguments as being justification for the idea that this court should say, oh, well, how the parties held their assets, separate property, this is something that can be relevant within the sharing principle. 153 and 170 of Miller, completely irrelevant to this case because those have been confined, as everyone knows, by the case of Charman and by the case of, in this court, XW and XH, to short, childless, dual career cases. It is only in those cases where the fact that a party retains some wealth in their sole name, that can be a relevant factor in relation to the application of the sharing principle. This is none of those, and therefore 153 and 170 have no relevance at all to this case. And then finally, on this point, and then I'll leave it for this afternoon, subject to your views, my lady, is the 2002 case of Para and Para. Now this is said to be authority for the proposition that the court should have a hands-off approach to redistribution and should respect what the parties themselves have set up regarding legal and beneficial ownership. That is not a correct reading of this authority at all. All Para does is say that if there is alignment between what the parties themselves have put in place and what would be the upshot of the application of the sharing principle, in this case 50-50, there was no non-matrimonial property, the court shouldn't tinker. Mr Justice Charles had readjusted things on some fairly obscure basis to a 53-47. And Mr Justice, the Lord Justice Thorpe there said, this was a fundamentally simple case. Everyone should just have left it as it was. But that's not authority of the proposition that generally speaking the courts will not redistribute when the sharing principle requires. And if you look at the end of paragraph 27 in Para, it makes it perfectly clear. Lord Justice Thorpe saying, when required, the courts will redistribute. He says, as a matter of principle, I'm of the opinion that the judges should give considerable weight to the property arrangements made during the marriage, and in cases where the parties have opted for equality, reserve the exercise of the adjusted powers to those cases where fairness obviously demands some reordering. And so, Para is no authority for the disapplication Miller and Hart at all. I'm coming on to a different subject, which is autonomy. Is this a convenient moment, my lady?
It is indeed. Thank you very much indeed. 10:15, please.